there. The remedy is insane. I
Yeah.
mean, it's one thing to talk about prospective relief, which would be bad enough, but then retroactively throwing out over 100,000 votes because you handed them through your car window to the person rather than walked inside. Like I cannot even imagine like what would possess a lawyer to
Yeah.
say, yes, this is how we win the election.
Yes, I've spent, my husband could attest to this. He's not at all, he's not a lawyer or an election law expert, but I've spent much of my weekend trying to calm people down about this case, to be honest, because I think that it is so far out of bounds. It would be, I mean, yes, it would be a coup if he threw out all those votes, but I think the likelihood of that happening is minuscule.
Well, our wonderful technology guy, Mike Mudrio, started streaming on YouTube. So I think that may be my cue to go ahead and get started. I just want to welcome everybody to this event of the Texas Federalist Society. For those of you who don't know me, my name is Tanner Baird. I'm the Executive Vice President of the UT Law Federalist Society. We are a group of law students who primarily believe that it is the job of the judiciary to say what the law is, not what the law should be. And we are dedicated to the free exchange of ideas on campus about important legal issues. One of those today is Bush v. Gore and the ramifications of what that means and what that might mean in 2020. So without any further ado, welcome everybody here. I'm going to go ahead and start introducing our wonderful panelists here today. First up, we have Jason Glahn. Jason Glahn, I'm so sorry, is a UT Law grad, former Texas Law Review member, and a committee member of the Jefferson City Lawyers chapter of the Federalist Society. He's currently a senior analyst and attorney working for the Missouri legislature, where he advises on elections, ethics, and redistricting matters. We also have Professor Mimi Marziani, who is president of the Texas Civil Rights Project. She has previously directed voting rights programs for multiple political campaigns and committees. Before moving to Texas, Professor Marziani was counsel for the democracy program of the Brennan Center for Justice at NYU Law School, where she litigated election law cases in federal courts across the country, including before the U.S. Supreme Court. She teaches election law and policy at UT Law and serves on the NYU Board of Trustees. Professor Marziani earned her JD from NYU Law School. And finally, we have Professor Michael Morley, who teaches at Florida State University and writes in the areas of election law, constitutional law, remedies, and the federal courts. He has testified before congressional committees and serves as a gubernatorial appointment to Florida's Criminal Punishment Code Task Force to propose potential revisions to the legislature. Before joining FSU Law, Professor Morley was a Clemenco Fellow and lecturer in law at Harvard Law School. Prior to his experience in academia, he served in government as special assistant to the General Counsel of the Army at the Pentagon and in private practice at Williams & Connolly in Washington, D.C. Professor Morley received his JD from Yale Law School. So with that, I'm going to go ahead and turn things over to Mr. Glahn. So thank you.
All right. I thought we'd just start with allowing both professors to talk about 10 or 15 minutes on the significance of Bush versus Gore itself. It's its 20th anniversary. Some questions in this area might be whether the Supreme Court was correct to take up Bush versus Gore at all, or whether the political question doctrine still has any life left in it whatsoever. Your initial reactions to Bush versus Gore and its equal protection holding. And then maybe a good question is whether Bush versus Gore is a unique decision, or whether it's kind of in conflict with Scalia's dictum that you shouldn't have a unique case. Has it developed into any sort of coherent body of precedent that can be applied today? So I will let you two have at it. Whether Bush versus Gore is a
That's a lot. Where should we start? Maybe we can try to go back and forth a little bit more than and take those in chunks. Let me start with the middle question on equal protection. Before I do, I'll just say that it's a pleasure to be here today with all of you. I think every year, maybe even twice a year, I do an event with UT's Federalist Society, and I am always very pleased to be invited and to participate. And especially now, of course, it is a very timely moment to be talking about Bush v. Gore on the eve of Election Day. So yeah, there is 20 years later, lots to talk about when it comes to that decision. Let me talk about the equal protection holding and what that looks like 20 years later. And I shared some of this on our prep call the other day. So I actually think that as far as an equal protection precedent, that Bush v. Gore has not had a lot of oomph in the past 20 years. And in fact, during this time frame, aided by Supreme Court cases like the Crawford decision in 2008, the federal courts have actually settled on a framework for evaluating equal protection claims around the right to vote. And that is the Anderson verdict balancing test. And so what that test requires is that when somebody challenges a usually state election practice under the 14th Amendment, that the courts will evaluate the weight of the burden on the right to vote. And they'll look at, the extent to which that burden is felt across populations, how severe it might be for certain populations. And then based on the weightiness, it will then ask whether the government has proffered a sufficiently weighty governmental interest. And so the idea, you can think about, I always think about it a little bit like the hands of justice, that you're trying to kind of balance the burden on voting with the government interest. And one of the reasons that this balancing test has developed over the years is because it is, one thing that is actually, I think, a direct ramification of Bush v. Gore is that Bush v. Gore was a symbol in many ways that the federal courts were open to election disputes. And since Bush v. Gore, the amount, quite frankly, the fact that like people specialize now in election law is a post-Bush v. Gore phenomenon. And it's also the case now that political candidates, political parties, all sorts of organizations that they've actually developed, people, lawyers with expertise in election law and have been much more litigious. And so as more people started bringing these challenges to the federal courts, as many of these challenges were coming under the 14th Amendment, the courts had to have some sort of test to adjudicate. And the Anderson verdict test has emerged because it is, of course, true on the one hand that in order for, that there have to be rules imposed in order to have orderly and efficient elections run. So, for instance, there has to be some sort of deadline for casting ballots, for applying for certain, pieces of the election system. But at the same, and so, all of those are going to burden the right to vote in some way. But there are ones that burden the right to vote in a more extreme way, or in a way that is particularly hurting more vulnerable groups. And when that starts to happen, then the courts ask the state to come up with stronger justifications. So I'll leave that piece right there. But those are my initial thoughts on at least the continuing significance of Bush v. Gore in the realm of equal protection, 14th Amendment challenges specifically.
So I'd also like to begin by thanking the Federalist Society, the Texas Law School chapter for hosting this event, and for Professor Marziani for taking the time out to participate. So I agree with Professor Marziani's perspective that the so-called Anderson verdict balancing test is at the heart of much election-related litigation, simply because it's the type of claim that you can bring to virtually any type of election rule, process, procedure. And the argument, as Professor Maziani explained, is basically that it is unduly burdensome, that you're restricting the right to vote too much, given the interests of the state at stake and how much the regulation at issue affects them. I would suggest, though, that Bush v. Gore establishes essentially a second alternate type of equal protection claim, right? The Anderson-Burdick test basically says this law is simply too burdensome, either on its face as applied to everybody or as applied to some subset of the public. Bush v. Gore has been interpreted by many federal and state courts as establishing what I refer to as a uniformity principle, which doesn't have the same breadth of application as just the Anderson-Burdick "this is too burdensome" objection. The uniformity principle traces back to the language in Bush v. Gore, which prohibits states from engaging in what the court referred to as arbitrary and disparate treatment of voters. And that in previous cases, in previous decades, the court had applied that in the context of voter eligibility, saying that in general, restrictions on who was eligible to vote would be subject to strict scrutiny. We saw this in the one person, one vote cases, that courts had to treat voters equally in the sense of affording their votes equal weight. And so Bush v. Gore extended those precedents and applied that principle to what has been called in the literature nuts and bolts principles of election administration, right? Something as narrow and dry and technical as what are the rules that you use to count ballots, right? If two different people are looking at identically cast ballots, they have to both basically come to the same conclusions, or at least they have to be applying the same rules to decide whether those ballots are valid. Otherwise, you're not treating voters the same. There's going to be materially different likelihood of different voters, the chances that different voters' votes will be cast. And so that violates equal protection. And so where you see uniformity principle claims is where voters participating in the same election are being subject to different treatment. So one of the earliest types of cases where this arose is with regard to voting machine certifications, where in the aftermath of Bush v. Gore, there were lots of reform efforts, right? Nobody wanted punch cards anymore, unsurprisingly. And so secretaries of state in many jurisdictions certified a range of voting machines, or a range, I should say, voting systems, right? Not even necessarily voting machines, ranging from very low tech, very inexpensive systems that had high error rates to more technologically advanced, sophisticated, expensive systems with lower error rates. And counties were free to choose for themselves which type of system to adopt. And so as a result, different voters participating in statewide elections had materially different likelihoods of having their votes counted because their voting machines had substantially different error rates. And so several
Hold on 1 second. I'm sorry. I just want to call out what's happening in the chat, and I'm wondering if we can do anything as moderators.
Yeah, I'm so sorry about that. We're working on kicking folks out. Mike, if you can help with that as well, I just continue and we're on that. Yep. Sorry about that.
Thank you. Understanding that's very distracting, but I was, so Professor Morley, well, I guess the question to everybody, to the extent we think we can continue, or should we pause?
I think they'll try and get control of it. So
Okay.
I guess we'll perhaps continue with Did you have a response to Professor Morley, Professor Marzion?
Can I just finish, or?
Sure. Go ahead.
So, I mean, other contexts along those lines where we've seen uniformity principle type arguments is where state law would expressly allow county level officials to determine what policies on certain issues should be, and where differences in those policies could materially impact people's likelihood of being able to cast a vote and have it be counted. Several courts have said the uniformity principle kicks in there as well. One of the big challenges, I would suggest, is a tension between this uniformity principle, which I suggest embodies like a fairly common sense, basic fairness notion that people participating in the same election should have materially equivalent opportunities to vote, substantially equal likelihoods of being able to have their votes accepted and be counted. On the other hand, there's a line of precedents going back to the going back to the civil rights era. Where I'm thinking of cases like Katzenbach v. Morgan, McDonald versus Board of Election Commissioners, where the court said, as long as the government is trying to reduce barriers to voting, is trying to expand access to voting rights, that the court will only apply rational basis scrutiny, even if those additional opportunities to vote are being offered selectively or only to certain groups of people or certain portions of the population, which is one of the reasons why, for example, you can have for-cause absentee voting, where only certain groups of people, like the elderly or the disabled, are permitted to vote absentee. And so there's a tension between, on the one hand, the notion that you want to treat all voters participating in the same election substantively equally. You want to ensure everybody has materially equal opportunities to vote, with the principle that anything you can do to expand voting rights is a plus. Anytime that the government is trying to make voting easier and reduce barriers to voting, we don't want to scrutinize that too heavily. It doesn't have to be an all or nothing thing. One potential concern, of course, is that to the extent there are regional disparities in the availability of particular opportunities, there can often be partisan overlays and partisan consequences, that especially if there are more opportunities in particular areas that or disproportionately have members of one party as compared to other areas where members of the other party lives, there could be potentially partisan implications, fairness implications. One case I'll briefly mention where we saw this tension played out was a Sixth Circuit case from 2012. I was actually involved as an intervener in it, on behalf of some military groups in Obama for America v. Houston, where through a very complex series of machinations, Ohio law wound up where anybody could vote early in the weeks up to Election Day, but early voting cut off the Friday before Election Day. But members of the military could vote in person over that weekend before Election Day. So basically, members of the military got 3 extra days to vote. And so the Sixth Circuit wound up striking that down, saying that it was unconstitutional for the state of Ohio to extend an extra early voting opportunity for members of the military, citing this uniformity principle. And they actually didn't, even though it was brought up in the briefing, they didn't discuss at all the countervailing Katzenbach-McDonald argument that because there wasn't a constitutional right for early voting in the first place, as long as the state was reducing barriers to voting, providing additional opportunities for voting, the fact that it was limited to a particular group, and in particular, the fact that it was members of the military, right, who could be deployed, who could be called out at a moment's notice, who could face, unexpectedly being away from Election Day, being away from their polling place on Election Day, the court said that wasn't enough to justify the law, precisely because the court said there's all sorts of other groups like police officers or medical personnel, emergency service personnel, who could also be unexpectedly called away. And so therefore, the unique circumstances that members of the military were in didn't adequately distinguish them from other groups within the electorate to warrant special accommodations. And so to the extent that Bush v. Gore does create this separate type of uniformity principle claim that's independent and apart from Anderson-Burdick, because the whole point of a uniformity principle claim is, even if it would be okay to apply that rule to everybody, even if it's not too burdensome, the problem is you're not applying it to everybody. You're treating people differently. And eventually, I think the court is going to have to resolve that tension between the uniformity principle, to the extent it chooses to retain it and affirm it, versus the civil right, the notion going back to the civil rights era cases that as long as you're expanding opportunities to vote, making it easier to vote, reducing barriers, you don't apply strict scrutiny. You act very deferentially. You defer to states. You defer to the federal government.
I appreciate everything you said. There's a couple things I wanted to note, and hear a little bit more from you about it. I have a little bit of a different reading of that Ohio case. But before we get to that, Professor Morley, full disclosure, I have been meaning to read your article on the uniformity principle, and it's been a busy couple of weeks, so I haven't quite gotten there. So you may have addressed this already, but what I find so fascinating about because I do agree with you to start. I mean, one, I don't agree with the, some of the dicta in the Bush v. Gore majority opinion that suggests that it can't be precedent, right? I mean, that's clearly not correct. It cannot actually be limited to the specific facts or whatever the exact language is. So I agree with that. I also agree with you that, and I think I shared this before, I mean, at CCRP, we have sued at times and used Bush v. Gore as a separate formulation of the 14th Amendment. So I also do agree that it has been used and it hasn't been developed to the robust extent Anderson verdict has, I think probably for reasons that you noted. One thing that I've been pondering and at some point want to do some more research on is whether you think this sort of, prohibition on arbitrary and inconsistent treatment, right? Which is what the court ultimately rejects in Bush v. Gore, whether you think that is best characterized as a 14th Amendment uniformity principle, or whether this is actually a due process principle, right? Because there's something, and I think especially the facts of Bush v. Gore feel due processy to me. It's this idea that you're changing settled expectations after the election, and then there's an arbitrary variation. So I have a couple of thoughts, but one, I wanted to hear, and you're nodding like you've probably thought about this and addressed it in this article I'm meaning to read, whether you think this could or should be better characterized as a due process claim.
Well, I totally agree with you about your interpretation of the due process clause, right? I mean, I'm thinking here primarily of the 11th Circuit's ruling in Roe versus Alabama, right? The notion of changing the rules of an election after votes have been cast, especially after there's been reliance on that particular rule, raises due process concerns because it goes to the fundamental fairness of the process. But I would suggest that that is still a separate claim, right? That basically you have Anderson verdict, this is too burdensome. You have Bush v. Gore, the uniformity principle that regardless of when the rule is adopted, even if the legislature passes the rule well in advance of the election, intentionally treating different groups of voters differently, intentionally affording, right, arbitrary and disparate treatment to people participating in the same type of election is a second type of claim. And then under the due process clause, whether you're doing it to everybody, whether you're doing it just to some people, in which then you might also have an equal protection claim, ex post changing the rules raises fundamental fairness concerns that go to due process. So I wouldn't collapse the uniformity principle with the due process concern, especially because I do think the uniformity principle sounds in equal protection, right? Like the gravamen of the complaint is you are not affording equal treatment to people participating in the same election, whether that's by expressly grouping them differently, whether that's by conferring discretion on county level officials to afford differential treatment to people within the context of statewide elections, or whether that's what happened in Bush versus itself, which is you have a statewide standard, but it is so vague and so general that it's susceptible to substantially differential interpretations, materially different interpretations on a county by county level, thereby resulting in different treatment. So I think the due process claim is yet a separate claim that you wouldn't want to roll this into, especially because you could have a uniformity violation even if you're not changing the rules of the election, even if the violation occurred in advance of the election.
Thank you for that. On the Ohio cases, the Hunter, I forget the exact name of it, you probably remember because you were involved in the litigation, but those 2012 cases, my memory of the facts is that what actually triggered the lawsuit, it was not the case that the legislature said, we think that members of the military are in a particular situation where they need more time to vote, and we have a 2-week early voting period, and we're going to tack on an extra weekend for the military. My understanding of the facts is everybody at some point had access to voting in that weekend, and it was rolled back, but it was back in a way that was selective, which I think, to me, sounds much more like, the kind of the flags that you were noting of this tension, between, wanting to allow some bend in the joints so that there can be local variations, or there can be special treatments for certain special populations that need them, but at the same time, trying to guard against partisan game playing in some way. And so I guess I'm just curious to hear a little bit more. It wasn't totally apparent to me from your description. Like, in your view, where did the uniformity principle from Bush v. Gore, like, what were those cases rightly decided in Ohio? Which way? I'm actually not clear which way you thought that cut.
So you're absolutely right. And in part, this is against the context of there had been litigation about Ohio's election laws over a multi-year period. There were many amendments to the election code. Part of what was going on in the courts were just trying to figure out what the statutes meant and said anyway. And you're absolutely right. During the previous election cycle, the early voting period, including that 3-day window, had been available to everybody. And in fact, the court ran both an Anderson-Burdick and a Bush v. Gore type analysis, though I would suggest it perhaps maybe commingled them more than it should have. But it basically looked to the data from the previous election cycle where that extra window was open and said, okay, a lot of people in particular, right, members of traditionally marginalized communities, took advantage of this period. And so therefore, based on this empirical data about how people chose to vote in the past, that supports the notion that it is a substantial burden under Anderson-Burdick and therefore isn't justified. And then, like I said, separately, in looking at the state's defense of the statute, right, where the state's position is, regardless of how we got here, right, this isn't a Section 5 type case where we're engaging in a retrogression analysis. That basically the fact that it used to be the law that there were these 3 extra days is more or less irrelevant outside of a retrogression type analysis. The question is, through however we got here, we now have this statutory scheme where everybody gets to vote until Friday. Only members of the military get to vote these 3 extra days. There's enough of just military status in and of itself is enough of a rational basis to distinguish members of the military from everybody else. So therefore, given that we are expanding opportunities to vote, we're creating opportunities that the Constitution doesn't mandate us, right? And no one argued that early voting is constitutionally required, especially, over the weekend before Election Day. The state basically said this should be rational basis. This falls within Katzenbach v. Morgan, McDonald v. Board of Election Commissioners, and you should uphold this. The court rejected that argument, as I had mentioned before, saying, sure, members of the military are faced with unexpected emergencies, but so are other people, and so are members of other professions. And so therefore, rather than looking at this through a Katzenbach v. Morgan or civil rights era case lens, we're going to be looking at this through a fairly robust interpretation of the uniformity principle and basically say it's all or nothing. You have to treat all the voters participating in this election equally.
So in this current election period, are we going to be looking more at challenges to individual ballots and ballot types? Like, have they pretty much solved the problem of these hanging chads and butterfly ballots and all that kind of thing? Or are we moving towards litigation over kind of administrative rules or rule-based litigation instead of ballot by ballot litigation? Let me
try to answer that, because this was the next point I was going to raise. I mean, I think another so lots to dissect from that question. I mean, one thing I was going to raise for folks to think about is one lasting effect of Bush v. Gore is it did prompt the last major federal legislation we've had on voting rights. This was the Help America Vote Act of 2002. And the Help America Vote Act of 2002 has several components that were intended to address lots of caveats here, some of the problems in Florida. And it included, for instance, more money to states to upgrade their voting technology. And I don't have the text of the law in front of me. I believe that was tied to states not using the punch card machines. And so, so that was part of it. It also created the Election Assistance Commission, which has been, quite frankly, has never been really gotten off the ground. But I think the intent was that the Election Assistance Commission would be kind of an evergreen body that would provide guidance to the states and administrators around voting technology. HAVA also created provisional ballots. So this is a great segue to talking about what we can expect past the election. Provisional ballots. The idea, the reason there is because, there are actually a lot of problems that happened in Florida, not just what went to the US Supreme Court. One of the issues, many issues in Florida, was that there had been a widespread voter purge of people who were suspected of having felony convictions. This was done on faulty data and then bad list matching practices, but lots of other technical things there. But the upshot is that it ended up wrongfully disenfranchising thousands of eligible voters and disparately impacting Black voters in Florida in particular. And so that was completely without any recourse after the election without provisional ballots, because there was no way for, instead the folks who were ultimately disenfranchised, they showed up at the polls, they weren't in the voter registration rolls, and they left. There was no mechanism to preserve their vote while election officials looked to see whether they were in fact kind of eligible, including properly registered. So that's another piece of HAVA. So just a couple thoughts on that, and I'd love Professor, Morley's, and then we can maybe segue into like the post-election period. So HAVA, it is safe to say that 18 years later, HAVA is not going to be our life preserver in the next couple of days. The provisional ballots now have become commonplace as mandated by HAVA. Provisional ballots, though, completely depend on underlying state law. So and then they are actually, speaking of concerns about arbitrary treatment, I've done some research showing that provisional ballot rejection or acceptance has wide variations. I mean, of course, from state to state, which you would expect because they're dependent on state law, including questions of, under what circumstances you get a provisional ballot, under what circumstances you can cure it. In addition, I did a very interesting analysis in Texas a couple of years ago and found pretty significant variation between Texas counties, which cannot be accounted for, of course, by state law, and are very troubling because it strongly suggests that there are arbitrary and inconsistent treatment of those provisional ballots. But the post-election point is that is a category of ballots that on their face suggests that there has been, something has run amiss. Maybe it's as simple as somebody showed up and thought they were eligible to vote and they legitimately never registered, which is the bulk of provisional ballots. But it can also be, some of those are curable, and then it can also be a sign of underlying issues. So I do suspect in close, and it is the case in close elections, that provisional ballots always are the subject of litigation and probably have been responsible, honestly, for better and for worse, for spurring additional post-election litigation. Because, in my experience working for candidates, if you're in a close election, once the dust settles the day after the election, the first question you ask is, how far, if you're losing or winning, what's the vote difference and how many provisional ballots are there? And that's exactly where you start in every election contest. Then one other reason that HAVA is not going to save our country in the next couple of days is that To be sure, the punch card machines that created the hanging chads that are, seared in our memory, that amazing photograph that, is in every time capsule from 2000 of that guy with the magnifying glass looking at the chad. Those machines were bad. They routinely undercounted votes. It's a good thing we don't have them anymore. However, there's several problems with the technology we've instituted since then. I mean, one problem is that the federal funding came in one big lump sum for the most part, but the biggest bulk of federal funding came in 2002. And so it's in a lot of Texas counties, especially poorer ones, there are people voting who are younger than the voting machines themselves. And think about your house. I mean, we don't have any technology in your house that's still from 2003. And so we actually had a kind of a crisis on voting machines. And that's another thing that very much could spur election contests post-election, is the age of the machines and the fact that, between the age and just the fact that we have different variations of election machine technology, they are prone to screw up in all sorts of ways that I'd be happy to get into if you're interested.
I totally agree with that entire analysis. The only thing I would add to that is if you think about an election, right, whether in terms of a recount, post-election litigation, election contest, I think it's helpful to think about three piles of ballots, right? You have the ballots that were cast in person on voting machines. You have your absentee ballots, whether they were accepted or whether they were rejected. And then finally, you have your provisional ballots, including the ones that are ultimately get counted and don't get counted. The ballots on the ballots cast in person at polling places, you could have as many recounts as you want, right? But especially to the extent that they're cast on some sort of, whether it's a ballot marking device and a ballot scanner, whether it's a VVPAT, an electronic voting machine. You could have a recount as many times as you want, unless somebody forgot to put in a memory card from one of the machines and calculating that original tally, which would be immediately apparent, by the way, because there would be a tremendous disparity between the total number of votes cast and the number of signatures of people who signed into a polling place. You're going to come up with the same outcome every time. So to the extent you're going to see substantial changes in the results of an election afterwards, it's going to come from those other categories of ballots. Now, Professor Marziani talked about provisional ballots, right? So particularly because each provisional ballot, the whole reason that a provisional ballot is cast is because there's some problem with somebody's voter registration, or they don't have the right ID, or their signature's not matching. Some states will treat problematic absentee ballots as provisional ballots instead. That gives candidates an opportunity afterwards to observe that cure period, to observe when election officials are going back and ruling on whether those ballots are going to get counted or not. That, right, person by person, right, evidence-based exercise of judgment, that is a major opportunity for post-election litigation. The same with regard to absentee ballots, right? You have a pile of absentee ballots that have been rejected. If your election is within the margin of that number of votes, right? If more ballots have been rejected than the leading candidate is ahead by, well, what's the trailing candidate going to do? Try to get those ballots counted, right? Especially to the extent that you know where those ballots were from, right? The whole point of their being rejected is they haven't been opened yet, so you don't know who they've been cast for, but you do generally know who cast them. And so you can generally get a good sense as to, is this person registered in my party, or based on other information, the zip code, things like, you can tell, is this from an area where the voter's likely to be supporting me? And that would provide a fertile ground for post-election litigation as well. So challenging both election officials' decisions with regard to those categories of ballots, right? Not just the provisionals, but the absentees. But then also, and particularly as a result of COVID, right? One of the things that I would suggest is unique about this election cycle is just the uncertainty over the rules governing the process itself, right? Usually, even with Bush v. Gore, even in the presidential election cycles following Bush v. Gore, you had most litigation, to the extent it happened at all, was post-election litigation. There were a few, thinking back to the 2008, 2012 election cycles, there were some pre-election cases in Ohio. There was a case that wound up going to the US Supreme Court trying to force the Secretary of State to match voter registration records against DMV records. And the Supreme Court unanimously rejected it, saying HAVA didn't create that a cause of action for that particular, to enforce that particular statute. In 2012, there were some voter ID cases, a few other cases like that were litigated on an expedited basis before the election. But this cycle, we had well over 100 cases filed before a single vote was even cast. The last I checked, I forget if it was 325 or 425, literally hundreds of state and federal cases.
425.
420. It was the worst. I didn't know if I was being a pessimist. 425.
So is it fair to say that the actual precursor to Bush v. Gore, the Palm Beach versus Broward County case, and its kind of interpretation of the term legislature in the federal constitution might come into play quite a lot in this particular election?
I mean, I think it has, like that so you're referring to this, independent state legislative doctrine. We should talk about that. It is being raised. I do think, going to Professor Morley's point, though, the headline is every claim is being raised because everything is complicated. And I do think, and we were talking about this in my class the other day, and I actually think it's very interesting that we have, in some ways, it's a perfect storm in 2020 between Rick Hasson. Professor Hasson he keeps track every year, every cycle of election-related disputes. And you can see, it keeps increasing, that we are becoming more litigious around elections in general. And then you have COVID-19, which actually did require rules to be changed in order to keep voters safe while running an election. And, obviously there's all sorts of opinions on what exactly those changes should look like, but everybody agrees that something had to be changed. And then you have it's a presidential election year where, unless people have been hiding under a rock, you will not be surprised to hear me say that people feel very strongly on both sides. And I think that all of these things have careened together, just the uptick in litigation overall, the fact that all of a sudden election laws had to be changed. And a lot of people were saying, wait, I don't like that change over here. I do like this change over here. It is always the case. It is just, it is naive, I think, to ever try to separate election law changes from politics, because it's just true. When you change rules, it changes the game, and people are always trying to evaluate. Lots of times people are quite frankly unsuccessful, but people are always trying to guess who is going to benefit from rules, but that spurs litigation. And then on top of that, you have a bunch of people feeling that this is an existential moment. Oh, and I would add one more on that, which is we have not had the benefit of Section 5 of the Voting Rights Act since 2013. And whatever else one could say for or against Section 5, one thing that folks have to agree on is it provided a built-in notice mechanism for changes in election law, and it slowed down the pace of change. And so because of that, potential litigants found out about changes earlier, and there was a heavier weight, especially on the mostly southern, not totally, New York City, where I used to live, for instance, also subjected to Section 5, but it put a finger on the status quo, so it slowed the rate of change. And so all these things are churning together right now, which is how you get just a jaw-dropping amount of litigation. I mean, in Texas, we have, I keep meaning, maybe I'll count it up before I go to bed tonight, but in Texas alone, we have had dozens of cases in the year 2020, election law cases in state and federal court, which is incredible. So, okay, so the so-called independent state legislative doctrine, Let me actually I'm going to pivot a little bit to answer your question, because there is active litigation. This is my other screen, around drive-through voting in Harris County. And that is one of the claims that the challengers have put forth. And it's actually, at this point, it is their best hook to be in federal court today. And so I'll take a step back, and Professor Morley, I know everybody who's in election law is watching this very closely. So I'll do my best stab of kind of describing the state legislative doctrine, and then we can talk a little bit about whether we think it's going to come into play in the next couple of days. So the notion here is that we've already talked about the majority in Bush v. Gore found that there was an equal protection violation to the arbitrary and inconsistent standards by which the recount was being conducted. There's a concurring opinion in Bush v. Gore, and in which 3 justices, and Rehnquist writing for the concurrence, suggested that there was another federal law hook, and that it came into play when in that case, the Florida state court, but when a state court's interpretation of state law, which, remember, I'll step back for a second for all the, Fed courts classes people have taken. Normally, the state courts have the final say on state law. And so in that concurrence, Justice Rehnquist told us, or suggested, that there could be some exceptions to when a state court has a final say on state law. And this was in the context of a presidential election, because under Article 2, the plain language gives power to the state legislature to choose electors. And that in the case of the Florida state court, in Rehnquist's view, that the Florida state court was, its interpretation of Florida state law was so egregious and so disruptive to settled principles that it amounted to a wholesale change of state election law that had not been provided before by the state legislature. And that kind of articulation was, as the blogosphere noticed, echoed by Justice Kavanaugh last week. I don't know, my days are blurring together. And he used the term significant departure. So the idea that if a state court's interpretation of state law was such a significant and unexpected departure, that it could offend Article 2 and create a federal question. Now, I'm very interested to hear what Professor Morley says. I'll just give people a couple of things to think about on this. I mean, one, just to be clear, this is not something that the US Supreme Court has ever adopted. This was a concurring opinion in Bush v. Gore. The court has had, I mean, for 20 years, it has not adopted any sort of doctrine of this way. And actually, this argument was raised in the recent case coming out of Wisconsin. And again, a majority of the court declined to adopt it. So of course, what the court has done in the past doesn't necessarily tell us what it's going to do in the future, but this would be a new doctrine. I think it's important to understand. And then I think the other thing is, as I've been working on the drive-through litigation in Harris County, which is, as Professor Morley and I were in agreeing, is a very extreme, I think, version of this doctrine. But if you were to embrace an expansive view of this doctrine, I really think you start to turn traditional federalism principles on its head. I mean, look, what we're seeing in the drive-through litigation, I do think is indicative of what it could look like if this was an expanded doctrine. I mean, in that case, the litigants are claiming that they have a right to go into federal court to challenge state election law that has been interpreted by the Secretary of State, which is the legislature has already told us the chief election official in the state of Texas. That's the Secretary of State. Secretary of State said drive-through voting was okay. This issue is now going to the state Supreme Court twice. They have not booted it. And now a plaintiff's going to federal court and asking a federal court to provide a veto on all of those state entities. which, by the way, was this idea of a federal court veto on state lawmaking was expressly rejected by the founding fathers. And so, and like this idea that the federal courts could become the court of original jurisdiction for state election law disputes we would watch that 425 number go through the roof every even numbered year. So I guess all that is to say, I am personally quite skeptical that this doctrine exists. If it does exist, I think that it is quite narrow. And so, but I don't have a crystal ball, and I'm the first to admit that we live in a volatile time right now. So, I certainly would be interested to hear what Professor Morley thinks as we're looking at these really interesting next couple of days.
Great, thank you. So just to step back for a moment to explain, in case people aren't familiar with the doctrine, like where this comes from, right? So most of the time when the Constitution talks about states, right? So there are two provisions in the Constitution: the Article 1 Elections Clause, which deals with congressional elections; the Article 2 Presidential Electors Clause, which deals with presidential elections. Both these provisions say the Supreme Court has said these are the sole sources of constitutional authority to regulate federal elections, that states don't have some sort of inherent authority or 10th Amendment authority, that their power to regulate federal elections comes from the U.S. Constitution.
They do have the 15th Amendment and the other amendments.
Well, those are restrictions on state authority. Congress can certainly enact federal laws under those enforcement provisions.
Yes.
So these sources these provisions, the Elections Clause, the Presidential Electors Clause, are where states get their power to regulate federal elections. But the wording of these clauses doesn't say the power goes to the states. Instead, it singles out the legislature. It says the legislature of the state can regulate the time, place, and manner of congressional elections. The legislature of the state can regulate the manner in which presidential electors are appointed. And so the whole notion of the independent state legislature doctrine is that these grants of constitutional authority essentially pierce the veil of statehood, and rather than conferring authority on the state as an entity, it focuses that authority on a single branch, specifically on the legislature. And so then the question becomes, so what? What if anything flows from this? And there's different possible, whether you want to call them implications of the doctrine or variations of the doctrine. One of them, which is something that came up in Pennsylvania litigation this year, is the notion that because this power comes directly from the US Constitution, specifically to the legislature, that state constitutions may not impose substantive restrictions, may not limit that power in any way. So when a state legislature regulates a federal election, it is limited by the Constitution's express restrictions. It is limited by the 14th Amendment. It is limited by all of the voting rights amendments, 15th, 19th, 26th Amendment. It's limited by any federal laws that Congress may pass, but it is not limited by the state constitution. And throughout the 19th century, that appears to have been the prevailing interpretation of this clause, that there's a series of state Supreme Court cases, there's a series of congressional election contests where a chamber of Congress had to figure out which of competing claimants won an office. And in case after case where there was a conflict between a state statute that said one thing about a federal election and a state constitutional provision that said the other thing, the state Supreme Courts, the chambers of Congress went with the state statutes, which of course is the opposite of how we usually think about constitutional law. So it was one example is a case from the Rhode Island Supreme Court called in re plurality elections, where the state constitution said a candidate has to have an absolute majority to win. A state statute said to win a congressional election, a plurality was enough. So of course, eventually somebody won an election for Congress with just a plurality of the vote. And the state Supreme Court said, even though they didn't satisfy the state constitution's requirement, the state constitution was inapplicable. The state statute said you could win with a plurality, and therefore that person won. This also came up in the context of Civil War absentee voting, where state constitutions said you had to vote in person at your polling place. During the Civil War, the Union Army was off fighting the Confederates, and so some states passed absentee voting laws that would let soldiers vote away from home. And state Supreme Courts, the few that addressed them, upheld the constitutionality of those laws as applied to federal elections. Because again, they said these state constitutions can't limit that substantive grant of authority. So that's perhaps the strongest version of the argument, but it's also one that is rooted in 19th century practice. If you look at Cooley's Constitutional Limitations Treatise, he talks about it. As a matter of fact, the US Supreme Court applied that interpretation of Article 5 of the Constitution in a case called Lesser v. Garnett, where the Supreme Court upheld the ratification of the 19th Amendment, said the amendment expanding the franchise to women. The challenge was raised that some states' ratifications were invalid because their ratifications violated the state constitution. The Supreme Court said the power to ratify constitutional amendments isn't given to the state as a whole. It's given specifically to the legislature. So we don't care what the state constitution limits have to put on it. A more moderate variation of the doctrine, which is what Professor Marziani was talking about, is the doctrine more as a canon of statutory interpretation, that because the Constitution gives the legislature the power to regulate federal elections, executive officials and courts have to focus on what the legislature itself said. And so it's almost akin to a plain meaning canon of interpretation, where you can apply textually semantic canons, but you can't go beyond the statutory text to come out with completely unpredictable, atextual, unanticipated interpretations. Commentators disagree, but there's arguably some support for that in the Supreme Court's unanimous per curiam opinion in Bush versus Palm Beach County Canvassing Board, where the Florida Supreme Court had construed the state laws governing recounts. The Supreme Court said, in general, we would be bound by whatever the state Supreme Court said. However, this is a presidential election. In this unique context, the legislature's power is coming from the presidential electors clause. The legislature said a lot of stuff about the state constitution that suggested maybe the legislature's interpretation of state statute was being influenced by these extrinsic considerations. So we're going to vacate the opinion, remand it back down to give the legislature another shot. And sure enough, on remand then, when the case went back to the Florida Supreme Court, the court reached the same exact conclusion, but its opinion omitted any reference to the state constitution, and all it talked about was the plain text of the statute and textualist canons of construction. One thing I think is important to emphasize along the lines that Professor Marziani mentioned, number one, this is roughly similar to what we talked about earlier, the notion that due process prevents after the fact post-election changes. So depending on if the court were to adopt this approach, it actually might not wind up being a substantial departure from at least the extent to which some circuits already are willing to, in extreme cases, police the outer bounds of how state courts are interpreting state laws to prevent, unfair after the fact, potentially partisanly motivated manipulation. But the other thing that's important to emphasize is, right, for all of the Erie-related doctrines Professor Marziani noted, this isn't supposed to be an invitation for federal courts to step in and just de novo apply their own preferred interpretations or talk about the best reading of the law. This should be a very deferential review to the extent it exists. Think more along the lines of, right, is there clear error, right? You could go so far as maybe to analogize it to habeas review, right? Where did the state clearly get these issues wrong? Is it outside the bounds of any reasonable construction of the text? Because again, the point of this isn't to just allow wholesale plenary review of state law issues, but rather potentially, should the court choose to recognize it or reaffirm it, just lay out some independent outer check to ensure that the state court interpretation is within some very broad range of reasonableness to, again, right, to prevent after the fact rule changes, to prevent partisan manipulation. And then one final and perhaps the weakest and most narrow version of the doctrine would be this notion that election officials can't act without statutory authorization, that they need to be able to point to something the legislature did in order to regulate elections. And so there are a few random district court cases striking down, post-Bush v. Gore district court cases striking down acts that secretaries of state did because they, again, they were all very unusual circumstances. Like a federal court struck down an election law. The Secretary of State took it upon him or herself to come up with a replacement, and the district court said, you don't get to do that. That power wasn't delegated to you. You can't step in and come up with rules different from the ones the legislature came up with. And so other than those like very unusual situations, election officials have to be able to point to some sort of legislative authorization. And perhaps more expansively, the institutional legislature can't be completely excluded from the process of regulating federal elections, which then we don't have to get into it, but gets into the Supreme Court's 2015 ruling in Arizona state legislature versus Arizona Independent Redistricting Commission, which was a very bitterly contested 5-4 ruling in which the majority pushed back and rejected a lot of the logic of the independent state legislature doctrine. And a lot of people have, everyone agrees, it's certainly one of the biggest obstacles that would either have to be narrowed, or the parts that are dicta from the parts that are holding would have to be separated, or potentially, distinguished, or in the extreme case, overturned in order for the court to embrace the doctrine in the modern world. But the big takeaway, it's not a new thing. It's not a fabrication. Like during the 1800s, where we have, as a matter of the final thing I'll say, during the Massachusetts State Constitutional Convention of 1820, the state attorney general proposed an amendment that would require the state of Massachusetts to elect members of Congress and presidential electors in districts. And Justice Joseph Story and Daniel Webster argued against it, saying the state constitution couldn't limit the legislature's power. Their argument carried the day, and the proposed amendment failed.
Excellent discussion. Tanner, did we want to try and take a few audience questions?
Well, so it looks like there is one question in the Q&A there. We are running short on time, so maybe just a quick response. I don't know if you can see the question or not.
Oh, go ahead, Tanner.
Sure. So we have from Richard Hood. Richard asks, he says it's not really law related, but he'd like to hear some of the problems encountered with voting machines. Do we see software problems, hardware problems? I guess that's kind of a view of our election integrity. Is it possible that these things can get hacked? Is it possible that they just don't work? From that perspective, and then maybe what's litigation about around that?
Thank you for the question. I'm aware of the timing. Let me just say that, yes, we have all the above problems with election machines. They vary in most states from county to county, and many of them, as I said, are quite old. If you want to learn more about voting machines, actually, I would encourage. I will say most of the litigation, as far as what has totally failed, actually, is this idea that you can challenge different voting machines. Us having a different voting machine in Travis County versus what they have in Harris County. Those challenges have been routinely struck down by courts, because you could see a logical extension after Bush v. Gore. A number of those types of challenges were brought. They were not successful. I think there are still some challenges one could bring to voting machines in certain circumstances. What I would tell you, though, is actually the Brennan Center for Justice, where I worked for several years, has done a lot of really good and helpful, and some of it, quite sobering analysis of the age of voting machines, the technological problems, the fact that private companies control the software and hardware. I've actually personally been in lawsuits. A lawsuit once where I won the lawsuit, and the counties had done such a bad job. I won't even say what state this was. They'd done such a bad job of negotiating the contracts with the election machine companies that they basically were paralyzed and almost unable to change the things about the voting machines. And so, there's a lot of problems swirling in there. And then that's even before you get to the fact that, they very much are, there's national security implications Absolutely. So anyway, I think I will leave you to research that more. And I think just a pitch that, honestly, no matter kind of what side you come at looking at voting rights and election law issues, I actually think, quite frankly, that investing seriously in our voting technology is something that every single American should wholeheartedly embrace, because it is like one of the entry points to making sure that our elections are both fair and secure.
Any other thoughts on that question, or is that everything?
No, I agree. I mean, I think the only other thing worth mentioning is that if you want to get federal funding for your machines, you have to pick from among those that are certified by the Election Assistance Commission. So there's at least some outer bounds on the quality of the machines. And in fact, this past year or so, they were going through the process of adopting new standards for the next generations of machines to meet. Before the machines are hooked up, and I mean, this varies by state law, but they have to go through logic and accuracy testing. So this is something that's publicly available. A set of known ballots is basically run through the machines. However, the machines accept votes in order to confirm that the people who are supposed to be winning are the ones who actually win. Due to just the sheer number of machines you have, the age of technology, one of the most common systems you'll see, and again, every election cycle, like I guarantee you tomorrow, you will see newspapers, the machine changed my vote, right? A lot of them, to the extent that you have touch screens, it comes down to just calibration. That particularly if you ever had like an old style video game, when you press the screen, then the mark like appears slightly off.
Yeah. I'll note several counties in Texas still have very old, purely touchscreen machines. So I almost guarantee we see it every election. You will absolutely see that. And unfortunately, many times they are true, that voters are not losing their minds. We don't have straight tickets voting anymore, but that is where we've seen it in past cycles, that somebody votes straight ticket Republican and it flips to straight ticket Democrat. I have personally never seen any indication that there is actually, it was intentional manipulation, but it is, the machines are old and the calibration gets off.
And so for exactly those reasons, a lot of times it'll get hyped up in the media as, mysterious conspiracy regarding the machines, when either it's just the calibration on the screen is off, or sometimes even just unintentional user error where the screen is fine, but their hand brushes against another button. They don't necessarily realize that they touch it. They inadvertently wound up changing their vote. So certainly, I mean, from a big picture level, anytime there's internet connectivity, right, you definitely want to be very concerned about that. That's something that's certainly well beyond my area of technical expertise. But with regard to the voting machines themselves, most of the problems that you tend to encounter, and certainly most of the problems that tend to get reported in the press, are more along the lines of just individual one-off old machines, for hardware problem or possibly user error, and not a larger scale threat to the integrity of the process.
All right. Well, I thought I might ask one final question about legitimacy. I suppose we have to come to some result on this election thing we're having tomorrow. So from your perspective, would it be best to leave it to the entire state apparatus, the state legislature, the U.S. Congress, or the U.S. Supreme Court? And there's probably some alternatives I haven't thought of, or mixture thereof, but just from the standpoint of overall legitimacy and accepting the result, which one of those might you think be the best?
I mean, I think the best thing we can do is follow the rules that were laid out in advance of the election. And quite frankly, it is a complex system that has roles for all of those institutions. And I mean, I will say that I often joke that I made it my job to sue the government because I consider myself very patriotic. It's actually not a joke that I consider myself very patriotic, but it's kind of a flippant way of saying it. But I think that one of that truly we do actually have processes for all of this. I mean, look, it is not ideal, for instance, for states to send competing electors to Congress, but we actually have a process for figuring it out. And I think that the biggest threat, to be quite blunt, is the biggest threat to our democracy is ourselves. And that if people are not, are not willing to kind of have the patience and be thoughtful and, really make sure that you're listening and investing in trusted information. Because it is, we are very used to in this country usually figuring out the results on election night. Probably won't. It is actually completely normal, for instance, to count votes after election day. We do it every single, Professor Morley can tell you, representing members of the armed forces, every single election, we count votes from members of the armed forces, particularly people serving our country overseas, and that those votes are usually counted after the election. There's nothing abnormal about that. It's why states' certification periods are weeks after election day. And my strong view, the best course of action is for us to calmly proceed down the path that has already been established. Because I do think, there's been a lot of strains of actually, I think something Professor Morley and I very much agree on, and there's some doctrine to back this up, but I think there is a big threat in unsettling expectations after election day, because it is like any other thing that has rules around it, right? People, I think, will accept the results if they understand the process and they think the process was fair. And one of the best things we can do to have people accept results and make sure they think it was fair is to actually follow the process that has been laid out. Now, I recognize that's a lot easier said than done, but I think fundamentally that is what not just should be done, but quite frankly has to be done for the sake of our democracy.
I, again, wholeheartedly agree with everything Professor Marziani said. And I just want to underscore two points. Number one, as you think back to past elections, every election night result you've ever seen announced is always unofficial, right? When you hear the elections being called, that's not the government calling the election, that's the media calling the election. So elections have never, ever been officially settled and definitively ended on election day itself, for all the reasons Professor Marziani identified. Maybe there may be provisional ballots. The whole point of provisional ballots is their eligibility needs to be sorted out after election day. Depending on the deadline for returning absentee ballots, if you're in a postmark jurisdiction, you might not even have all the absentee ballots yet, much less have gone through, processed them, counted them. Military and overseas votes can take as many as 10 days after election day. And so there is no basis in the Constitution, federal law, anything for the notion that, it's not Cinderella, right? When the clock strikes midnight, you stop counting and everybody turns it back into a pumpkin. No, you count all the legal votes. And then the one final thing I want to add along the lines, again, just to underscore what Professor Marziani said, you want to know the rules ahead of time. One of the creaky parts of the process is that at the end of the day, the ultimate winner is determined in the joint session of Congress on January 6th. That joint session where the chambers of Congress get together, they take all the electoral votes, they figure out which ones are valid, which ones are going to count. If a state sent in more than one slate, they figure out which slate they're going to accept. That process is ostensibly governed by a federal law called the Electoral Count Act. And I added that qualifier because there's some law review articles questioning, is that constitutional? Can they actually bind themselves? If so, can you do it through a statute? But even putting that aside, it was written in 1887. It is confusing. It is poorly drafted. In certain important ways, it is ambiguous. It leaves very important measures unaddressed. So one ostensibly nonpartisan thing after this election cycle is over, well in advance of the next election, would be simply clarifying the ECA, modifying the ECA, not to even necessarily to change the rules or to give one side or the other an advantage, but just to resolve the unnecessary problems. Fill in those gaps, resolve those ambiguities, clarify the procedure, clarify the power in particular of the vice president as the presiding officer of the chamber, because number one, by its very nature, this isn't the sort of issue that can go to court. So it's not as if you can just run to the Supreme Court and get a ruling. The statute doesn't create a prior right of action. It would likely be deemed a non-justiciable political question. There's all sorts of problems with trying to sue Congress, sovereign immunity, legislative immunity. And so this would be left for the chambers of Congress to resolve themselves. And you would much rather have them do that as a matter of abstract legislative debate ahead of time, rather than in the midst of a hard-fought election with passions at their maximum, where control of the White House is literally hinging on it. So the best time to fix the ECA would have been a few months ago. The next best time will be as soon as this election is over.
Very good information.
I agree with that completely. All of that.
Tanner, would you like to close us out?
Absolutely. Thank you. This has been fantastic. I really appreciate our panelists' insight, and I guess I can only cross my fingers that our political discourse in the weeks following this election is going to be as civil and as well informed as what we've heard today from our panelists. But I have my doubts. But I really appreciate this event. I do want to apologize again to all of our panelists and our attendees for what happened in the chat today. Never had an issue like that before, but we're just going to know to shut the chat down from the beginning now. But I just want to be real clear. We apologize for that. Sorry that people had to see that. On a brighter note, the UT Federal Society will be hosting our last event of the semester, and that'll be on next Monday. And that will be a debate between John Yoo and Sai Prakash over presidential power. So we may have a new president in line by then, and we'll see what people's thoughts on presidential power are at that point. But we're going to have a great event there. I look forward to seeing everybody there. And again, that's next Monday. Thank you again to our panelists. Thank you for everybody who attended. And I think that we're adjourned.